Hello, friends. Today we are going to discuss about a case which was filed by a widow of the deceased, and she has filed a quashing petition for quashing of all the matrimonial proceedings, which was filed by the father of the deceased. So, this particular petitioner was the wife of the deceased who passed away, and when he passed away, his father has filed a suit for the annulment of marriage against the present petitioner who has filed a quashing of all the matrimonial proceedings filed by her father-in-law. So, father-in-law of this petitioner has alleged that his son has died due to the contamination or due to the HIV/AIDS, and when he passed away, he got to know that petitioner was HIV positive, which was later on revealed in the reports. However, there was no report of any death of the deceased occurring from that HIV positive. And thereafter, the female has faced a petition under Section 11 and 12 for the annulment of marriage. That marriage never existed because she had hidden this fact of this disease. However, under the provision of Section 5 and Section 11 and 12, if you read in the entirety, there is no provision as such that the marriage can be annulled on the basis of this disease. Yes, there is a provision of a mental disorder, but there is no provision that this the marriage can be annulled on the basis of this disease. So there is no provision as such. Therefore, she has filed this petition, and High Court has seen and observed the entire proceeding, and they have given the complete reference of Section 5, 11, and 12, and they have stated that there is no proof that the deceased who passed away was a victim or was suffering from HIV, as there was no proof of that disease. And moreover, the incubation period of HIV positive take almost 8 to 12 years. So there could be the other reasons for petitioner being contaminated with HIV positive, which has just came now. And thereafter, High Court has allowed the appeal of the petitioner for quashing of those proceedings arising out of that annulment.